Welcome to Mentoring with the Masters. My name is Jennifer Kuyrkendall. I'm the Third Circuit Representative for the Young Lawyers Division Board of Governors. Today we have the honor of speaking with the 2013-2014 President of the Florida Bar, Eugene Pettis. Gene is going to be speaking with us about developing a theme for your case from threshold to trial. Gene, thank you so much for being here today.
It's a pleasure being here, Jennifer.
Gene, what are some of the factors that you consider in developing a theme for your case, from the time that client walks through the door to the time you're giving your closing arguments?
I think it touches upon a critical part of litigation that's often overlooked. Sometimes we see lawyers who handle cases in what I call a disjointed fashion. You know, they answer the complaint, take a deposition, mid-case, think about a mediation. If the case doesn't settle, end up in trial, and then they try to start coming up with their themes at that point in time. But many times it's too late because some of the evidence that you're going to use, whether it's depositions or whether you've even started planning the theme in the mind of the judge, has already taken place. So it's critical that we start thinking about it from day one. And in my practice, and I've tried nearly 70 cases, some lasting 5 months, 4 months. You know, I've had 2 different trials at those 2 different lengths. So I've been in court a lot, but I think it's really important that from day one, when you get the complaint, I start thinking of what is my theme? And I do both plaintiff and defense litigation. So if a family is in my office with a particular set of facts, I'm thinking about how will that play out ultimately to the jury, because that's the end point. If it resolves before then great. But you want to be able to have a string through your case that takes you all the way to the end to be safe, that there's some continuity in the case. So if it's on the plaintiff's end, you listen to the story of the family and you think about what types of claims and what would be your angle or your theme of the case. If it's on the defense side and you get the complaint, I'm immediately thinking about, from experiences, what's going to be my theme here? And in my practice, I have what I call mini conferences with my team, and whether it's another lawyer who's going to work with me on the case, my paralegal, my nurse that's working with me on the case. And it's important that they understand your theme, because you being on one page and others that may touch the case on another will again lead to inconsistencies in the case. So literally in the first 10 days, I'm meeting with my team. Here are my thoughts. What are your thoughts? To get their input. And then you start developing your theme. It's not to say that your theme will not evolve over time. Obviously, as more information becomes available, I adjust my theme a little bit to address that new information. But I have found from experience, with that theme going into my case, it helps dictate what are my motions that I want to file. Do I want to attack this? Do I not want to attack it? Does leaving that in lead to a better case for me at the end? So just because you can dismiss something doesn't mean you should dismiss it. Sometimes leaving it in gives you more attack points. And I think that's true from either side of the case. So strategically thinking about what dispositive motions to dismiss, motions for summary judgment, within the context of your theme. So you have to have the theme early on to start making those type of judgments. When you look at some trials, I get lawyers who get up and I can't recognize any connectivity from their jury selection to their opening statement to their closing argument. And certainly at that stage of the game, we must have connectivity. You must ask questions. Even in the preliminary phases, start setting up questions for the judge to start thinking about, challenges for the judge to start thinking about that tie into where you want to end up on a case. When I pick juries, I spend a lot of time, whether it's called conditioning or just trying to learn more about the prospective jurors, but it's all based on what my theme is going to be. And if you can get people commenting on your theme, if not commenting, thinking about your theme, getting the whole venari to think about the theme, it's so much more smoother when you lay your case out. They've already been awaiting that particular evidence because it's a part of your theme. I get up an opening statement and I tie in. You'll recall, some of you commented in the Vadar process about X. Again, that's my theme, and that's really important because of the fact that you're going to find in this case, that's going to be a critical consideration of yours. Now, wow, they have a life experience that they've shared with me in the jury selection process that's going to be a part of the case. They're in tuned to that piece that happens to, by coincidence, be my theme. And that's a smoother process through the case. And when you get up for closing argument, now you recognize, they recognize that you're able to tie it all together on a foundation that they have in common with you. I think it leads to a much better result. So as early as the client walks in the door, or as early as the claim is called into you, if it's on the defense side of the case, I think it really behooves you as a lawyer to start at day one thinking about it with the understanding that themes evolve. Don't be afraid of letting it evolve, but always having one in place is critical.
Certainly. Some lawyers may not have had the opportunity to experience a trial advocacy class while in law school, so maybe have never used a theme in their cases before. Could you give us a real-life example of a theme that you've used?
Yes, that's a good question. Again, as the case has unfolded, I try to set my cases up. I like real-life emotions. I like themes such as credibility. Who believes that credibility is an important part of life? Everybody raises a hand. Mr. Johnson, why do you think that? Well, because it's essential to us as human beings. It's what we should be doing. Do you agree with that, Mrs. Smith? Now you're setting that theme on, and the question is prompted on something that I know, I hope, 99% accuracy, everybody's going to agree with it. Credibility. So, when I get up, I've talked to them about credibility, and I get up to do opening statements. Now, guess what my theme is? Credibility. This is a case about credibility. And even though you may not be comfortable with passing judgment, one of the things you're going to be instructed as a juror to do by Her Honor is to judge the believability, the credibility of the witnesses, of the plaintiff, of my witnesses. And I invite you to look at the credibility in this case. And I believe once the evidence is all out, you're going to see that the story that's been presented here is not credible. It's not believable. Why do I say that? Let me tell you why. So now I got a theme of credibility that's based on a common value of ours. We all want to believe in believability and credibility. So I love interweaving that. Whenever I have that, that's one that I always keep in my pocket because it's such a core value of ours. Other themes that you always use the term common sense. If there's a debate between two witnesses, one said it happened this way, one said it happened that way. You talk about, I often say, my mom taught me early on to use your common sense, just your gut. What makes sense here? You know what? As we navigate life, we make pretty good decisions just using our God-given common sense. You're going to have to use that in this case. You're going to have to use your common sense as you listen to the evidence. Does it make sense? Every single thing we put before you, every single thing they put before you, ask yourself, does it pass that test? I submit to you what they're going to tell you, or if it's in closing argument, I submit to you that what they have argued of X, Y, and Z doesn't pass the simple common sense test. Why do I say that? Does it make sense that such and such? No, that doesn't make sense. Why would they? You use that theme. Again, working on you must develop your case based on themes that are the jury is going to be able to understand, believe in, and connect with. Excellent lawyers talk about justice. Who could argue against justice? Everybody believes in justice. So if you could take that term and weave the facts into it, That's always a term that's a good theme in the case, that you can talk about how our system of justice was built on, you know, what the principles are, and get people emotionally tied, because once you have people connected to your theme that happens to connect to their core beliefs, now you got a jury who's more likely to be favorable to you and your client. But that's the importance of thinking about this all the way through. When I litigate on significant cases, I'm planting my themes by questions that I'm asking in the first deposition. You're talking, would you agree with me that common sense would dictate such and such? Well, yeah, I would agree with that. So I'll tell them, you're going to hear that even the plaintiff, even the defendant, thinks common sense should be in play here. You ask, how do I know these things? I've taken the depositions of the party, and they're going to tell you that they think common sense would dictate such and such. So as early as that, I got a theme that I'm developing. It does not hurt if you let the theme go. You know, you're in the midst of the case, you're in a year of litigation, and the common sense theme is no longer really playing for you. You can let it go, but at least you thought about it and you had options in what you utilized going forward. The critical piece, and I mentioned it a second ago, is not waiting to the end to sit down. The case is going to trial, and now to start thinking about what you're going to use as your theme. Why? Because if you do it that way, the facts that you've gathered are going to dictate the theme, as opposed to you thinking about the winning theme and building facts around it. And there's a slight difference there. When you build from the beginning, you have the ability to be more consistent. When you're at the end the week before trial and you're trying to come up with it, you're boxed in. And you're not going to have the questions in the depositions that are going to be read. You're not going to have the questions. You don't know the answers, how these jurors are going to, how the witnesses are going to respond to some of these thematic type questions. So now you're shooting from the hip, which is not what you want to do. So it really is a ribbon that flows through the entire case from the beginning to the end. But those are some of the type general themes that I use in cases often.
Well, you've certainly provided us a lot of very good practice tips in developing a theme from when the client comes in the door to trial, through all stages, depositions, everything. So we appreciate you so much for your time and being here.
Thank you so much, and thank you all for having this program. I think it's great.
Thank you.
You're welcome.